Sometimes it is necessary for a person to become a quasi-parent for another adult. Hi, I'm Chris Wilms, and I'm one of the managing attorneys in the Estates Department here at Hopler, Wilms & Hanna. Guardianship for an adult goes through a particular court process. And sometimes when a person has reached a certain point of cognitive decline, or they have an illness where they have a degenerative disease of some sort that's affecting their mind, or because of an accident or some other trauma, a person cannot handle their own financial affairs or their own medical decisions or making good decisions about their own residential care. When a person reaches a certain level where they just cannot handle things on their own anymore, and it becomes necessary for them to do something that they can't do because of their lack of capacity. That could be anything like protecting yourself from exploitation or from scams. It can be paying your own bills. It can be all kinds of things. So when a person reaches that level where they can't do something, it doesn't have to be everything. They don't have to be a complete vegetable, but there has to be limitations of some sort in that person's ability to manage their own affairs. And when a person reaches that point, they may need a legal guardian appointed by a court that will then have the power to sign things on their behalf and transact business as if they're the person, so that the person's needs are met, whether it's their financial needs or their personal needs or their medical needs. A lot of times these cases are initiated by social workers at hospitals or at facilities. When a person is in need of a guardian, whoever files it, whether it's a family member or a facility employee, someone will start that process by filing a petition with the court. And each type of case that you have in court is heard in a different division of court. So if you want to go to family, if you have a family law case, you want to sue someone for custody or something like that, you might go to district court. And if you want to sue someone for $100,000 in civil damages, you might go to superior court. Well, this type of proceeding to sue someone and ask that the court declare them legally incompetent and appoint a guardian, that's heard before the clerk of superior court, which is an elected position, and it includes a role like a judge where they handle things like foreclosures and incompetency proceedings for adults and dealing with minors' money and deceased people's estates. And so this judge is going to be the one that decides whether the person is in need of a legal guardian, and if so, who should be that legal guardian. One of the things that the court relies on is the appointment of a guardian ad litem, which is an attorney that's been specially selected by the court to be an advocate for the person that's being accused of being illegally incompetent. So that advocate is usually a trained professional who's going to be interviewing the person that's accused of being incompetent, talk with the family, review medical records, and talk with other professionals. And eventually they're going to write a report and tell the court exactly what they think should happen. While they're there to advocate for the person and they are an attorney, they're not the same as an attorney in this particular type of role. As a guardian ad litem, it's possible that the person accused of being incompetent may lack insight into their illness and may not believe that they're legally incompetent or that they need a guardian at all. And so they may tell the guardian ad litem that they want them to go to court and advocate for a position that says that there should be no guardian appointed. Well, a guardian ad litem would be advocating for the best interest of the person, not necessarily what the person wants. And so they may go to the court and they may say something different. They may say that the person is in need of a guardian, but they will always tell the court what it is that the person wants, and they're required to by statute. Well, in addition to a guardian ad litem that reports to the court what they believe is in the court's or in the person's best interest, they also will rely on medical records and anecdotal evidence very heavily. So having doctors' affidavits and having other evidence is very important. Now, even in a case where everyone gets along, a person knows that they need help, the children are applying to take over and they've all agreed on who's going to do what, and nobody's fighting about anything, even then you have to go through all of that I just described. Now, if a person retains their own counsel to defend against the allegation that they need a guardian, that may indicate that there's some sort of contestation, that it's going to be more than what would otherwise be a straightforward guardianship proceeding. It may be that there are multiple interested parties involved. Whenever a person is adjudicated incompetent, that court proceeding is a lawsuit against the person. So the person is served with notice of that lawsuit, and they're given an opportunity to defend themselves. But they're not the only ones that are served. It's required to serve all of the next of kin and other interested parties to the proceeding who would want to be involved in that kind of proceeding. And how that's defined is a little beyond the scope of this video, but it is a large group of people potentially, and it could be people who are all very well-meaning or nefarious or some combination, but they may have very different opinions about who should be appointed and whether the person needs a guardian at all and what particular type of care the person needs. And all these can be a source of disagreement among family and other interested people. And when that happens in this setting, it can be like World War III. People often will delay these proceedings. It could take a long time to get through, and it can be very costly. And one of the things that you have to keep in mind with proceedings like this is that there are extremely short appeal deadlines if you get an unfavorable ruling. And by the time you get into an attorney's office to even talk about it, a lot of times the deadline's already expired. So you want to make sure that you put on good evidence in that first effort that you have to try to get the best interests of this person adjudicated properly. So you want to go armed to the teeth with all the evidence that you would need and all of the information that you would need to show what outcome is in this person's best interest. And we can help you with that. If you are a person who's trying to see after the care of another person and you've recognized that there are unmet needs for that person, and you think that a court proceeding to get legal authority over them might be necessary, you can call our office or contact us right through our website using the contact page that we have. And we can talk to you about that and help you determine if that's appropriate, make appropriate referrals to help get you the information that you need. And we can give you a guiding hand through that process. And whether it's straightforward or it's World War III, we're very capable and qualified to assist you with that. If you'd like to know more or reach out, we have free resources that on our website that you can download that give you a lot more detailed information about this topic and other related topics. But if you need more help, reach out to us online. We'll be glad to assist you with this important matter.